Hello, my name is Kevin Wilbee, a lawyer in southwestern Ontario. When you separate, do you have to go to court? No, you do not. You have other options, including negotiating a separation agreement, mediation, or arbitration. Especially if you have kids, going to court is not the place to be, because court is adversarial. You must always consider what is in the best interests of the children. So it's important to work together with your spouse to find a solution that works for everyone. Negotiating a separation agreement with your spouse is much friendlier and much less expensive than going to court. It also gives you a lot more control and certainty. What's involved in a separation agreement? In a separation agreement, if there are children, the agreement will outline the decision-making and parenting, custody, access for the other parent, child support, and other issues relating to the children. Child support is based on the support payer's income in accordance with the child support guidelines. Special expenses are divided proportionate to the income of the parties. Spousal support. Spousal support is payable based on the number of years married, your age, and on the difference in income between each spouse. The duration ranges from half a year to a year for each year of marriage. Spousal support can be indefinite if the marriage was for 20 years or longer. Property division, which is also called equalization, is the wealth that you have accumulated from the date of marriage to the date of separation. It is the wealth you have gained during the marriage that is equalized and divided. As a general rule, any money and personal property that you had before you got married is yours and not divided. Other examples that are not divided include inheritance, life insurance proceeds, and personal injury settlements. Matrimonial home. Both spouses are entitled to half the value of the matrimonial home upon separation. As a general rule, this is the case even if you put more money into the house than your spouse, or if you owned the house before you chose to live in the house together as the matrimonial home. What if I decide to go to court? If you decide that you want to go to court, you will need to file various documents. It begins with a family court application, an affidavit in support of custody, if there are children, and a sworn financial statement. If the respondent lives in Ontario, he or she will have 30 days to serve and file an answer to the application. Both parties will be required to attend a mandatory information program that provides information about the family court system and process, as well as local community resources and programs, among other things. The next step is a case conference. This is a meeting at the courthouse with the parties, their lawyers, and a judge. The purpose of a case conference is to discuss settlement of the issues. For the issues that are not resolved, the parties will proceed to a further settlement conference, and from there to a trial management date, and then to the eventual trial. Most family law cases reach settlement at some point in the process. Going through a trial is expensive and adversarial, so only a small percentage of cases go all the way through a trial. Who am I going to get to help me? Going to court can be stressful and confusing. You want a lawyer who has experience and is compassionate. A lawyer who knows the family law rules, the case law, and the court process. As a lawyer, I help guide people through the legal process, outline their options and what it will cost them to pursue their options, including not just the financial cost, but the emotional cost as well.